The market capitalization of the coin is used to summarize all that is taught in this video. I would also like to remind you to give my channel a kind subscribe to it so that you can stay up to date on future XRP news as well as other cryptocurrency news in general. Take a look at this now, shall we? As Alderoty contemplates the possibility of regulation, Judge Torres is mulling over the ruling in the case of Ripple versus SEC. As of right now, Riplabs Inc. and the United States Securities and Exchange Commission are involved in a landmark case that is now being adjudicated upon by Judge Sarah of the Southern District of New York. There is another name for this lawsuit, which is Ripple versus SEC. Ripple's XRP token is at the center of this lawsuit, which has significant implications for the cryptocurrency industry. The topic at hand is whether or not the XRP token meets the definition of a security according to the laws of the United States. The confrontation that was taking place in the courtroom became more intense as a result of the fact that both parties presented their arguments in front of Judge Torres. Ripple has indicated that XRP is not a security but rather a digital currency that is analogous to Bitcoin and Ethereum. This is an allegation that the company has made. XRP, on the other hand, is a cryptocurrency that the Securities and Exchange Commission believes deserves to be classified as a security. They claim that Ripple was involved in an unregistered securities offering that was worth billions of dollars and that they participated in the securities offering. With regard to the appeals in the CVs and Ripple cases, the opinions of specialists and a large number of other individuals, including Mikkel and investment advisors, are taken into consideration. For the United States Securities and Exchange Commission, the case that is currently taking place between Ripple and the SEC is likely the most ineffective one that they have ever been dealt with. Despite this, the attorneys pointed out that there was still potential for appeals against earlier conclusions made by either of the parties engaged in the case. In the case of Ripple versus the Securities and Exchange Commission, the judges Annalisa Torres and Sarah Netburn are currently discussing a number of motions that have been submitted. Included in these motions are those that pertain to the testimony of experts, documents that have not been sealed, as well as the outcome of the verdict. Sherry, an expert in the case of Ripple vs. CC, has stated that certain attorneys like Fred Rispoli and James Murphy have proposed that Judge Torres might give the ultimate ruling about the remedies phase in the months of July or August. This would allow them to circumvent the motions that are presently being reviewed by Judge Netburn. If the State Securities and Exchange Commission decides not to appeal the case, it will have a negative impact on all of the cryptocurrency matters that they will be handling in the future. In addition to this, she inquires about the rationale behind Ripple's choice not to submit an appeal in order to contest the finding that sales conducted through Odell constitute offers of securities or other securities. There is an increase in the amount of revenue that the company receives as a consequence of the sales of XRPO. They do not need to be concerned about the financial ramifications of their acts because Judge Torres will decide the amount of the penalty and provide an explanation. Ripple and the XRP are not responsible for the consequences of their actions. It is the manner in which an injunction is worded that is the most significant component that will determine how it is carried out. In a statement made by Mark Fagel, a former attorney for the Securities and Exchange Commission, it was said that the SEC had publicly announced its intention to appeal the proceeding. Furthermore, speculation might be made regarding the outcomes of other examples, revisions to strategy or policy, and other developments that are comparable to those described above. As soon as the Securities and Exchange Commission SEC files an appeal against the summary judgment, its principal worries will be the prospect that their prior interlocutory appeal will be denied, as well as the likelihood that the case will be escalated to the Second Circuit Court. The altering regulatory atmosphere surrounding crypto assets was investigated in a movie that was distributed by the European Union Information Agency on July 26th. The video was distributed through Alderoty, who is the chief legal officer of Ripple. In his analysis of the regulatory frameworks of the United States, the European Union, and the United Kingdom, Alderoty highlighted the differences between the MiCA of the European Union, the Financial Services and Markets Act 2023 of the United Kingdom in the regulation by enforcement approach of the United States. An expression of his dissatisfaction with the way crypto rules are being enforced in the United States was made. One can count themselves fortunate that members of Congress belonging to both parties have reached a consensus over the clear regulations. Alderoty proceeded by saying that in order to discriminate between good and bad actors, regulators need to use the concept of calibrated regulation to ensure the safety of investors and to facilitate the smooth adoption of technical advancements without causing any significant disruptions. The value of XRP has reached $0.60, representing a 1% rise over the previous day's price. a high of $6,089 and a low of $0.59 have been hit by the price over the course of the past 24 hours. Additionally, there has been a perceptible decline in the volume of trading that has taken place throughout the course of the preceding day. Both the cryptocurrency community and the authorities in charge of the financial sector are eagerly awaiting the resolution of the case that Ripple has filed against the Securities and Exchange Commission (SEC). This is due to the fact that the case has the potential to set a precedent for the regulation of digital assets in the United States of America. If the court decides in favor of Ripple, it will not only be able to provide clarity, but it will also be able to pave the way for regulatory regimes that are more liberal as they pertain to other cryptocurrencies that are comparable. However, a decision that is favorable to the Securities and Exchange Commission might have far-reaching repercussions, including the prospect of more stricter regulations and enforcement actions being taken against other digital asset issuers. This is one of the potential outcomes of such a decision. The legal team that is representing Ripple, on the other hand, continues to have a hopeful perspective regarding the outcome of the lawsuit. They have been underlining the decentralized nature of XRP as well as its value as a bridge currency in international transactions. In particular, Stuart Alderoty, who serves as the general counsel of Ripple, has raised attention to the necessity of legal clarity in the context of the cryptocurrency ecosystem. He has highlighted the role that regulatory clarity plays in fostering innovation and protecting investors. The cryptocurrency industry continues to remain on edge as Judge Torres continues to weigh the arguments that have been presented by both sides. They are keeping their fingers crossed for a decision that has the potential to transform the regulatory environment for digital assets in the United States. The Bitcoin and Blockchain Journal serves as a source of current information regarding the most recent events that have taken place in the domain of cryptocurrencies. Keep an eye out for further developments as a result of the potential settlement claims that Ripple and the SEC have reached. There is now a trend toward a growth in XRP. If these settlement actions are validated, there is a lot of conjecture about them, and if they are confirmed, the price of XRP might surge. In recent times, the sentiment of the cryptocurrency market has fueled a bullish surge for the cryptocurrency known as XRP. This increase was spurred by persistent reports that Ripple Labs and the United States Securities and Exchange Commission would reach a settlement in the near future. As we mentioned earlier, the price of XRP has been slowly climbing for the entirety of this month, and it recently achieved a new high of 8.1 for the first time since April. To our knowledge, this is the very first time that it has surpassed that level. According to the current state of affairs, Ripple may face possible challenges. The discussions for a settlement are still taking place behind the doors, and the particulars of the criteria that are expected to be included in the anticipated settlement are still unknown. On the other hand, legal professionals have begun to offer their thoughts on the repercussions of a prospective settlement and in determining whether or not it would be to the favor of one party over the other at this moment in time. In the legal conflict between the Securities and Exchange Commission and Ripple Labs, which began in December 2020, it was alleged that the organization improperly raised more than 1% of the total $3 billion through the selling of coins. This was noted in the previous section. A showdown is still regarded to be the possibility of a settlement, despite the fact that nearly 4 years have passed since the conflict began. On the other hand, Bill Morgan, an attorney who is in favor of XRP, is of the opinion that the possibility of a settlement is quite improbable. He contends that a settlement might lead to the formation of certain hurdles that might not be in the best interests of either party. He believes that this could become a problem. Due to the fact that a settlement will demand compromise on both sides, he is of the opinion that it will not result in a significant victory for Ripple Company. It should be noted that the material that has been supplied is not intended to serve as business advice.